Major U.S. immigration updates, October 2025 policy shakeup. The U.S. immigration system has entered one of its most unpredictable phases in years, with major rulings, raids, and rule changes all happening at once. From visa revocations over social media posts to Supreme Court decisions and massive workplace raids, every headline now carries real consequences for immigrants and visa holders. Visa revocations over social media. In one of the most alarming developments this month, the U.S. State Department revoked visas for 6 foreign nationals because of what they posted online. Those individuals, from countries including Germany, Brazil, and Argentina, were accused of celebrating or making inappropriate remarks about the death of conservative activist Charlie Kirk. Officials labeled the comments as inconsistent with American values, sparking outrage among legal experts who say this blurs the line between security and free expression. This incident marks a dramatic shift in how the U.S. government evaluates visa eligibility. It's no longer just about paperwork or background checks, it's about your digital footprint. Immigration officers are now routinely reviewing applicants' social media, searching for posts they consider anti-American or threatening to public order. For visa holders, this means every tweet, photo, or sarcastic comment could become a reason for denial or revocation. Even lawful permanent residents and long-term visitors are being warned to think carefully before posting politically charged content online. If you're a visa holder, make your profiles private, stay professional, and avoid engaging in heated political debates publicly. Supreme Court keeps H for spouses working. In a major relief for thousands of immigrant families, the U.S. Supreme Court has refused to hear a lawsuit challenging the H for employment authorization document rule. This rule, first introduced in 2015, allows certain spouses of H-1B visa holders to legally work in the United States. The challenge, brought by a group called Save Jobs USA, claimed that the Department of Homeland Security lacked authority to issue those work permits. However, lower courts upheld the rule, and by declining to take the case, the Supreme Court has effectively left the existing system intact. For many immigrant families relying on 2 incomes, this decision offers much-needed stability after years of legal uncertainty. It's a small victory, but one that provides immediate reassurance for those who have built careers and businesses under H-4 EAD status. Still, immigration lawyers warn that future administrations could try to roll back the rule through new regulations rather than lawsuits. For now, H-4 visa holders should renew their EADs early, maintain updated documentation, and stay informed about upcoming policy reviews. This moment of relief may not last forever, so preparation and awareness remain your best defenses. DHS moves to limit student visa duration. The Department of Homeland Security has proposed a sweeping rule that could drastically shorten how long foreign students and exchange visitors can stay in the U.S. Currently, F and J visa holders are admitted for duration of status, meaning they can remain as long as they maintain enrollment and lawful activity. Under the new proposal, students would instead receive a fixed 4-year stay, after which they must apply for extensions and additional vetting. Officials argue that this change would reduce visa overstays and academic abuse, but universities warn it could discourage international enrollment and hurt U.S. competitiveness. For graduate students, researchers, and PhD candidates, the new structure could make completing long academic programs extremely difficult. Frequent extension filings would also increase costs, uncertainty, and paperwork delays for thousands of students every year. Although this rule is still under proposal, DHS appears determined to tighten long-term visa categories and reintroduce stricter review mechanisms. Students are advised to track their academic timelines, maintain perfect compliance with school reporting requirements, and plan extensions well before expiry. In a climate of increasing scrutiny, small procedural mistakes could carry major immigration consequences. Blocked expansion of speedy deportations. A federal judge has just halted one of the administration's most aggressive deportation initiatives, the expansion of expedited removal. The plan would have allowed ICE to deport undocumented immigrants anywhere in the U.S. without a full immigration court hearing, as long as they couldn't prove 2 years of residency. Advocates argued that this policy would have denied due process to thousands, while government officials said it was necessary to clear massive case backlogs. The court disagreed, ruling that such authority must remain limited and subject to judicial review. For now, the decision restores basic legal protections for detained immigrants and prevents fast-track removals in the country's interior. However, the government is expected to appeal, and the case could reach higher courts in the coming months. For immigrants at risk of deportation, this ruling provides valuable breathing space to seek legal representation and apply for relief. If you or someone you know faces detention, act quickly, gather identification, prepare proof of residency, and contact a qualified immigration attorney immediately. Court victories like this one are temporary, but they can mean the difference between removal and relief. ICE raid, the human cost of enforcement. In Georgia, a massive immigration raid at a Hyundai electric vehicle battery plant shocked the nation and exposed the human toll of aggressive enforcement. Nearly 475 workers were detained in what officials described as a targeted compliance operation focused on employment verification and document fraud. However, eyewitnesses reported widespread confusion, fear, and even mistaken arrests among legal workers during the chaotic operation. The raid temporarily halted production and triggered diplomatic tension with South Korea, whose officials demanded accountability and worker protection. Immigrant advocacy groups are calling this a reminder that workplace raids often punish laborers rather than the corporations employing them. For foreign workers, this incident underscores the importance of maintaining valid work authorization, carrying documentation, and understanding your legal rights at work. Employers, too, are under renewed scrutiny, with federal agencies tightening compliance checks and threatening steep fines for irregular hiring practices. The message from Washington is unmistakable: enforcement is expanding beyond borders, reaching factory floors, offices, and worksites nationwide. Restoration of parole-based benefit processing. In another key legal development, a federal judge ordered the administration to resume processing immigration benefits for humanitarian parole recipients. This ruling affects individuals in programs such as Uniting for Ukraine, Family Reunification Parole, and Cuban, Haitian, Nicaraguan, and Venezuelan parole initiatives. Thousands of applicants had been left in limbo when the government attempted to suspend or delay processing earlier this year. The court found that the administration acted unlawfully by withholding adjudication and required USCIS to continue processing pending applications nationwide. This decision restores hope for families waiting for work permits, status adjustments, or travel authorization under these humanitarian programs. If you or someone you know is part of these initiatives, check your case status and consult your attorney about reopening any denied applications. Class action registration details will be released soon, so staying updated could ensure your eligibility for relief. While the legal battle continues, this ruling reinforces the judiciary's role in ensuring fairness and accountability in immigration administration. Immigration enforcement, politics, and the road ahead. Beyond individual rulings, the broader immigration landscape in 2025 is becoming tougher, more polarized, and more unpredictable. Earlier this year, Congress approved over $170 billion in new enforcement and border funding, expanding detention capacity and ICE operations nationwide. The Laken-Riley Act, signed earlier this summer, mandates detention without bond for non-citizens charged with certain crimes, even before conviction. At the same time, new executive orders aim to end birthright citizenship for children of undocumented immigrants, a policy still facing constitutional challenge. Meanwhile, ongoing raids, social media screenings, and visa crackdowns are reshaping how America defines national security and patriotism in immigration law. For immigrants and advocates, 2025 is proving to be a year of testing resilience, legality, and constitutional rights. Awareness, documentation, and credible legal guidance have never been more important. Every update, rule, and memo now carries potential consequences. Summary. October 2025 has become a turning point in U.S. immigration policy. We're witnessing social media-based visa revocations, renewed scrutiny of student and work visas, massive enforcement raids, and new judicial interventions. Each story reflects a deeper struggle between security priorities and humanitarian principles. For immigrants, it's no longer just about applying correctly, it's about understanding the political climate shaping your journey. Stay vigilant, protect your rights, and keep your records in order. The system rewards preparation, not panic. If you found this breakdown helpful, don't forget to like this video, subscribe, and turn on the bell icon for future updates. Thanks for watching, see you in the next video.